Hello and good day to the lecturers. Today we are going to present our case study 1, which is Thai Mei Chen against United Eastern Resources Sundran Burhat and another 2022 4 MLJ09, presented by Group 17 of Arus Perdana. In our first case, the parties to the suit are the appellant, Tai Mei Chen, who is the daughter of the second respondent, director and a 50% shareholder of the United Eastern Resources, Sundran Berhad. And we have the first respondent, which is the United Eastern Resources itself, and the second respondent, Ng Pik Lian, mother of the appellant, and equally a director and 50% shareholder of the United Eastern Resources.
Now let's move on to facts of the case. So basically, UER has two directors and shareholders with equal shares, which make decision making and management deadlock. And in this case specifically, UER paid 1.8 million to redeem TYYR's property from BIMB. And upon the payment, BIMB actually agreed to release the title to UER. However, TYYR did not sign any memorandum of transfer, and they continued to collect rental income without telling and paying to UER. Because of this, appellant actually requested UER to sue TYYR. However, second responder refused to take any legal actions against TYYR.
So there are two legal issues in this case. The first issue is that whether the appellant satisfied requirements of good faith and the best interest of the company for leave to commence derivative action. And the second issue is that whether appellant's conduct in other proceedings negated good faith.
Now, let's move on to legal principle. Derivative actions are governed by Section 345 until 348 of the Companies Act 2016. A complainant includes a member or directors of the company, and the court leave must be obtained before commencing an action in the company's name, as well as a 30-day notice must first be given to all the directors. Under Section 348, Subsection 4, there are two requirements that the court consider. First, whether the complainant is acting in good faith, and second, whether it appears prima facie in the best interest of the company that leave to be granted. If you look at the first link of Section 348, Subsection 4, which is the good faith requirement, court noted that this test is actually subjective in nature, and the applicant must honestly believe that a valid cause of action exists with a reasonable prospect of success, and the action must not be brought for a collateral purpose or amount to an abuse of process. While for the second limb of this provision, which is best interest of the company, the court does not assess the full merits of the claim at the leave stage, and the focus is whether the company stands to gain substantially in money or money's worth, as well as the court also consider whether there are genuine commercial reasons for not pursuing the claim.
Now, moving on to the court's decision. The Court of Appeal allowed the appeal and set aside the decision made by the High Court. The court clarified that the requirements of good faith under Section 348 to Section 4 of the Companies Act should be assessed using a subjective test rather than objective one. For the first limb of Section 348, the court found that the appellant had acted in a good faith. As a director, she was carrying out her statutory duties under Section 213 and 245 of the Companies Act by acting in the best interest of the company and protecting its asset. There was no evidence that she acted for any collateral purpose or personal gain. For the second limb, the court held that the proposed derivative action was prima facie in the company's best interest. UER had paid 1.8 million for the property, but TYYR failed to transfer the property despite receiving full payment. Therefore, the company had a legitimate and arguable claim against TYYR. Since both requirements under Section 348 to Section 4 of the Companies Act were satisfied, the court granted leave for the derivative action to proceed against TYYR. Lastly, the decision in this case is significant because the Court of Appeal clarified that the requirement of good faith under Section 348 to Section 4 of the Companies Act should be assessed using a subjective test rather than an objective one. This prevents the leave stage from becoming a full trial of the merits and focuses on whether the applicant genuinely believes that the action is in the company's interest. The court also recognized that commencing a derivative action may form part of a director's statutory duties under Section 213 when it is necessary to protect the company's interests. Importantly, the court confirmed that personal or family dispute do not automatically negate good faith, provided that the action is genuinely brought for the benefit of the company. Overall, this decision provides a clearer guidance on the requirements of good faith and the company's best interest under Section 348 to Section 4. It also reinforced the role of derivative action in ensuring that the rights of the company can still be enforced, particularly where internal conflicts prevent the company from taking action itself. That's all from us. Thank you.
Assalamualaikum and good day. We are from Group 17 of Aris Perdana and we'll be presenting our case study 2, which is on the case of Lim Gim Eng and others against Ernst and Young and others 2026 MLJU 1230. Parties to the suit in this case, we have plaintiff, which is the investment client that consists of 35 individuals and corporate entities who entrusted their investment portfolio to SJ Asset Management Sdn Berhad or SJAM. Meanwhile, for the defendant, we have four defendants here. The first one is Ernst and Young or EY as SJAM statutory auditor and Securities Industry Act reviewer. While the second defendant, we have Tan Wai On as the managing director of SJAM and approved the Securities Commission representative. The third defendant is Analong Corporation Limited, who is an offshore shell company that is associated with the second defendant. And last but not least, the fourth defendant is SJAM, which is a licensed fund management company in liquidation.
Moving on to the facts of the case, SJ Asset Management Sdn Bharat or SJAM was a licensed fund management company regulated by the Securities Commission of Malaysia under the Securities Industry Act 1983 and later under the Capital Market and Services Act 2007. Its primary role was to manage investment portfolios on behalf of its clients. The client's fund and securities were held in omnibus accounts, meaning that the assets of multiple investors were pooled together instead of being kept in separate accounts. Following the collapse of Anderson in 2002, Ernest and Young, or EY, was appointed as SJAM's statutory auditor. EY audited the financial statements from 2002 until 2009 and also carried out Securities Industries Act and agreed upon procedure reviews between 2002 and 2006 as required by the Securities Commission. However, unknown to the investors and regulators, SJAM's management had been operating a sophisticated fraudulent schemes for many years. The managing director, Tan Wai On, together with the finance manager, Tan I Kiang, maintained two separate sets of accounting records and systematically diverted clients' assets from the trust accounts. To conceal this misappropriation, appropriations, they used an offshore company called Analog Corporation Limited as a balancing account by recording large artificial negative balances. This created the false impression that the company's records were accurate while hiding the missing client assets. The fraud remained undetected for several years. It was only after the BDO advisory was appointed to conduct an independent review in the April 2010 that the true extent of the fraud was uncovered. BDO's investigation revealed that the fraudulent activities had actually started as early as 1993, well before EY became the SJM's auditor. By June 2010, the analog account showed a negative balance of approximately USD 22.7 million, of which around 17.5 million USD has already accumulated before EY's appointment. As a result of the ongoing fraud, there was a significant difference between the assets recorded in the SJAM's books and the actual asset held by the custodians. The trust asset shortfall increased dramatically over the years, reaching approximately 71 million ringgit in 2004, peaking at 146 million ringgit in 2006, and remaining above 110 million in the 2009. Following the BDO's finding, an SJAM director lodged a police report, and the Securities Commission immediately intervened by issuing a show cause notice and revoking SJAM's fund management license on 2010 July 23. The company was subsequently placed into liquidation, while Tan Wai On absconded. On 23 March 2012, the 35 investors commenced legal proceeding against EY and the other defendants, seeking compensation for the financial losses they had suffered.
Now, moving on to the legal issues. In this case, we have identified three legal issues. The first one is duty of care, whether EY, acting as the statutory auditor of SJAM, owed a common law duty of care to the plaintiff as passive third-party investors. Second, standard of care, whether EY breached the standard of care expected of a reasonably competent auditor by failing to detect the fraudulent activities and massive trust asset deficiencies within SJAM. And lastly, legal causation, whether any alleged negligence on the part of EY was the cause of the financial losses or if they were primarily caused by the fraudulent conduct of Tan Wai On and his associates.
Now let's take a look at the legal principle of this case. Firstly, the duty of care. An auditor does not automatically owe a duty of care to third-party investors. and the court held that the liability only arises when there is a sufficient relationship of proximity, an assumption of responsibility by the auditor, and actual reliance by the claimant on the audit report. Secondly, professional standard of care. Auditors are required to conduct audits in accordance with the Malaysian approved standards on auditing, which is called MASA. They are expected to exercise reasonable skills and diligence. However, they are not guarantors that every fraud or irregularity will be detected. And the third one is the burden of proof. The plaintiffs bear the burden of proving duty of care, breach, causation, and damages. The discovery of fraud alone is insufficient to establish negligence without evidence that auditor failed to comply with recognized auditing standards. And lastly, the expert evidence. Claims that involving professional negligence must be supported by credible and independent expert evidence. The expert's opinion must be based on accepted auditing standards rather than personal views or hindsight. So, what are the court's decisions in this case? The claim against Ernst and Young dismissed. The High Court found that Ernst and Young did not owe the plaintiffs a duty of care because they were third-party investors who neither relied on the audit reports nor had a sufficiently close legal relationship with the auditors. Secondly, there is no deep professional negligence established. The plaintiffs failed to prove that Ernst and Young had breached the applicable auditing standards, and the court accepted that the audits were conducted in accordance with MASA and that the plaintiff's expert evidence was unreliable. And lastly, the losses caused by fraud. The court held that the plaintiff's losses resulted from the fraudulent conduct of SJ Asset Management and its controlling individuals. Therefore, Ernst& Young audit are not legal cause of the plaintiff's financial losses. SJ Asset Management, Taiwan owned and Underlong were held liable for fraud and breach of fiduciary duties. So in this case, we found three principles that are important. Firstly, protects the limits of auditor liability. The decision confirms that auditors should only be held liable where all elements of negligence are clearly established. This prevents auditors from becoming automatically responsible for every financial loss suffered by investors. Secondly, it enforces the importance of evidence. The judgment demonstrates that allegations of professional negligence must be supported by reliable expert evidence and compliance with recognized auditing standards. Court will not determine negligence simply because of fraud was later discovered. And thirdly, emphasizes causation. This highlights that claimants must prove the auditor's conduct directly caused their losses. Where the losses are primarily caused by fraudulent management, liability remains with the actual wrongdoers. This case strengthens Malaysian jurisprudence on auditor liability by balancing investors' protection with the need to impose liability where legal responsibility has been properly established. So that's all from us. Thank you so much.